Well, we actually have some other positive developments when it comes to privacy, and that actually is coming from a federal judge in D.C. Tell us what exactly, I know this is just kind of breaking right now. Tell us what exactly happened.
Well, yeah, so this just broke, and I have to, complete disclosure, I have not read the full decision yet, but...
How dare you? How dare you not have read the entire thing yet?
Essentially, what it says is this is a decision, some people sued the government saying you can't spy on all of our cell phone calls. This is a challenge to the what the government claims is authorized under Section 215 of the Patriot Act. It's the metadata snooping program. That is that the NSA and the FBI, not just the NSA, the FBI too, are collecting records showing every single person we call and, the length of those calls, the time and date when they were made for every single call made in the United States. This call that we're on right now, including every other call. So this is blatantly unconstitutional. The government and apologists for this policy routinely drag out a case called Smith v. Maryland to argue for why this is legal, for why the government has the right to keep track of every single phone call made in the United States. Smith v. Maryland is a 1979 case that had to do with the surveillance of one criminal suspect. Basically, long story short, cops wanted to know who was making phone calls to whom from a payphone, but they already had a suspect. They knew the guy they wanted. They just had to get the evidence to prove that it was him. So they put a pen register trap and trace on this phone, which told them which numbers it was calling, etc. And they did that without a warrant. The Supreme Court in 1979 ruled that that was justifiable, that they didn't need a warrant to see just the number that was called, not to listen to the content of the conversation. So this is the case that forms the justification for the NSA and FBI hoovering up all phone records made in the United States. Hundreds of millions of people are affected in this program, literally everyone who makes phone calls. And I think anybody who has, who can understand basic English would get what I just said is completely ludicrous. I mean, it's completely insane for the government to assert that a Supreme Court decision that had to do with obtaining the records of one criminal suspect applies to a cell phone surveillance program that covers hundreds of millions of people who are not suspects. And so today, the DC federal court found that no, actually, this program is probably unconstitutional. And this is a really great paragraph from it. The judge writes, "Indeed, the question in this case can more properly be styled as follows. When do present-day circumstances, the evolution in the government's surveillance capabilities, citizens' phone habits, and the relationship between the NSA and telecoms become so thoroughly unlike those considered by the Supreme Court 34 years ago that a precedent like Smith simply does not apply?" And then the judge says, the answer, unfortunately for the government, is now.
Nice.
Yeah, so that's really exciting. This judge is basically echoing what, privacy advocates have been saying for a long time, which is that it's patently ridiculous to apply Smith to the bulk records collection program. There are a bunch of other lawsuits. The ACLU is also suing in a constitutional challenge, saying this program violates the Fourth Amendment rights of the ACLU, which is a Verizon business customer. Mm-hmm. So yeah, exciting times to be alive. Finally, a day when it's not all bad news on the surveillance front.
Well, it's funny because the hardest thing for all these lawsuits was so many times when you're going up against these secret programs is getting some judge to admit you have standing, even though when documents and everything show that this affects countless hundreds of millions of Americans, a judge might say, well, you don't know for sure that it affects you, so therefore this lawsuit can't go through. And so we actually have a judge, and you had with the Verizon when the initial Snowden leak happened, you actually had the ACLU able to move forward with Verizon on that, but also with this in DC. That's a very positive note where you actually found that these two people actually do have standing going forward. So that is a big deal.
Yeah, that's exactly right. And like you said, the one person more responsible for that than anyone else in the world is Edward Snowden, and every American should feel grateful for his whistleblowing, putting his entire life at risk to basically give the American public the proof that we need to challenge these programs in court. Glenn Greenwald just tweeted a few minutes ago something like, when a federal judge says that program disclosed by a whistleblower is probably unconstitutional, does that mean he's a whistleblower yet? Because a lot of people have been saying he's not a whistleblower, he hasn't disclosed anything illegal. And this, of course, is the group of people who likes to say that Smith v. Maryland, the case about one criminal suspect, is applicable to collecting the phone records of hundreds of millions of people in the country.